The following program was produced by the United States Courts.
As the story goes, in December of 1955, a 42-year-old seamstress named Rosa Parks was arrested for refusing to move from the white section of a bus because her feet hurt, launching the famed Montgomery Bus Boycott. In reality, she was neither in the white section, nor was she too tired to stand. She was simply tired of giving in. And the story doesn't start there, but Rosa Parks' actions brought the crisis to a head, turning the nation's eyes to Montgomery and the issue over to the federal courts.
The mid-50s, the state of affairs in Montgomery was substantially the same as it was throughout the South. There were laws on the books that provided for separation of the races in almost every public situation. And that's all any African American in Montgomery knew anything about. But I realized that it didn't have to be that way.
And that change began on a downtown Montgomery bus the afternoon of March 2nd, 1955, when 15-year-old Claudette Colvin was arrested on her way home from school for refusing to give up her seat to a white passenger.
She had been taught that she had a constitutional right. She was not sitting in the section reserved for white people. She had paid her fare just like the white people had paid theirs. We tried her case. He found her to be a delinquent. We appealed that case to the circuit court, and ultimately the case was dismissed.
Rosa Parks was very involved in the Montgomery Improvement Association, the NAACP, and other organizations to advance the rights of African Americans. She was neither quiet nor reserved.
If we were going to solve these problems, she also knew it was going to take lawsuits in order to do it. She didn't know whether she would ever be asked to get up to give up her seat. But if the opportunity presented itself, I felt that she would refuse to give up her seat.
On December 1st, 1955, Rosa Parks boarded a bus here in downtown Montgomery and sat in the colored section. When the white section filled up and she was asked to move, Rosa Parks did just as Claudette Colvin did. She refused and was arrested. The news of her arrest spread quickly, and a few days later, the African American community rallied to commence the Montgomery Bus Boycott.
The decision was made that we was going to file a lawsuit. So we was claiming federal constitutional rights, and for those rights to be held, it had to be filed in federal court.
The question was how to make a case that you could bring in federal court, and that's what he did with Browder versus Gayle.
I had our leaders checking with people to see who had had problems on the buses and letting me know who would be willing to be plaintiffs.
In the months leading up to Rosa Parks' protest, 4 other women were arrested for the same offense. Ordinary people, a widow with 6 children, a secretary, a schoolgirl, and a teenage churchgoer. On behalf of them and others, attorney Fred Gray filed Browder versus Gayle, a federal class action lawsuit against Mayor Gayle and the city of Montgomery to end segregation on the city's buses.
When Judge Johnson got this case, the chief judge of the circuit would then appoint 2 other judges to the case, and Judge Reeves was appointed and Judge Lynn was appointed.
That case was decided in a 2-to-1 vote with Judge Reeves and Judge Johnson declaring the ordinances and state statutes to be unconstitutional.
Judge Johnson had been raised in a segregated culture. Judge Reeves had been raised in a segregated culture, and not just a segregated culture, but this very culture in Montgomery. And yet, they both rendered this decision, which was essentially counter to the very culture in which they had been raised.
On November 13, 1956, that decision was upheld by the U.S. Supreme Court and set precedent for numerous civil rights cases that followed. As a result, the African American community in Montgomery ended the year-long bus boycott.
The decision was based on a provision in the United States Constitution, in particular in the 14th Amendment, that says that persons cannot be denied the equal protection of the law. This means that all of us are entitled to equal protection regardless of our race or our religion or some other impermissible factor.
Little did we know when we started it that what happened in Montgomery has helped to change the landscape of this country. And at least it gives hope and courage to people to say, if the 40,000 African Americans in Montgomery, Alabama could stay off of the buses 382 days, then whatever problems we have, if we work together and make plans together, we may be able to solve those problems too.
I think the Founding Fathers wanted to develop a judiciary that was independent, that's why we were appointed for life, and that could render decisions that were not influenced by either the President or Congress. And it's that independence that allowed the judiciary, in particular the federal judiciary, to carry out the Constitution here in the South.
If we are to get to where we need to be, it's going to have to be federal judges who will be able to decide these cases and not be afraid of what someone may say or what may happen.
Decades after Rosa Parks stood up for her rights as a person of color, she remains an example of how all citizens can assert their rights by turning to the courts, the guardians of the Constitution.